On April 10, 2019, I submitted a writ of habeas corpus pursuant to Title 28 USC 2254 to the United States District Court of Eastern Washington. That case was initially rendered a summary judgment to the state of Washington, in which I followed up with a letter of consideration asking them to reconsider based upon Title 28 USC 1343 and the fact that the original jurisdiction has clearly been placed upon the district court. And any violation would be, of course, an abuse of discretion because judges are tethered to positive law. They don't have the right to be able to disregard those obligations that are established by statute. I then submitted a second supplement asking for reconsideration, to which once again they ordered the dismissal under summary judgment. So I took the case to the United States Circuit Court, giving them the opportunity to be able to make the right decision, do the right thing. And this is the notice of appeal to the Ninth Circuit Court of Appeals. Petitioner respectfully submits to the court for consideration this notice of appeal to final judgment of the district court. Petitioner has submitted a writ of habeas corpus pursuant to Title 28 USC 2254. This writ of habeas corpus is an original civil action. It is not a re-litigation or an appeal to petitioner's conviction or judgment and sentence. This writ of habeas corpus is a constitutional challenge to state action, specifically a civil rights violation as a result of the unconstitutional provision of the Washington State Constitution, Article 1, Section 26, which is directly and facially unconstitutional. Therefore, this civil action is controlled under the prescriptions of Title 28 USC 1343, and the district court has original jurisdiction. Title 28 USC 1343 states, the district courts shall have original jurisdiction of any civil action authorized by law to be commenced by any person. This statute is prescribed to redress the deprivation under the color of any state statute, ordinance, regulation, or custom or usage of any right secured by the Constitution of the United States, providing for equal rights of all persons within the jurisdiction of the United States. As a result, the district court had a legal duty to act and rule on this civil action first and before any other court, including the courts of the state of Washington. This is a plain, manifest error of constitutional dimension in the ruling. Black's Law Dictionary describes the term manifest error as an error that is plain and indisputable and amounts to a complete disregard of the controlling law or of the credible evidence on the record. This manifest error is plain and cannot be disputed, as the record will reflect that the court was informed numerous times of the controlling laws for this civil action, including, but not limited to, Title 28 USC 1331, Title 28 USC 1343, Title 42 USC 1981, and Title 28 USC 2254. And the United States Constitution. The court's complete disregard of the controlling law and breach of legal duty to rule on this petition first and before any other courts, including the courts of Washington State, has resulted in obvious miscarriage of justice as a result of plain, manifest errors as ascertainable by the evidence on the record. Therefore, this court now has the duty to act in order to preserve the integrity and honor of the United States justice system. Under Civil Rule 52A, the Court of Appeals generally must accept the district court finding unless the appellate court is left with a definite and firm conviction that a mistake has been committed. Exceptions to the rule of difference apply when 1. The legal issues at stake are insufficiently new, unformed, or otherwise need an appellate review in the application or fact of law is required. Number 2. The finding of fact is predicated on a misunderstanding of the governing rule of law. 3. In arriving at the fact finding, the district court considered improper evidence, ignored or erroneously excluded material evidence, or otherwise tried the facts in an incomplete or unfair manner. In consideration of the rule of difference, specifically exceptions 2 and 3 above, petitioner requests that the United States Court of Appeals perform a review de novo. And since this is a challenge of the constitutionality of a statute, pure questions of law are reviewed de novo on the premise that the district court is in no better position than the higher court to resolve them. In the court's review, and to prove without question the destructive acts and violation of rights secured by the United States Constitution, let the following facts be submitted to a candid world. The judicial branch has no right to demand that the people turn from or be subjected to laws that are contrary to their faith. Americans believe in us. We have laid our foundation upon truth and justice. Our strength and unity is in our laws. They and faith in them is what unites us. Demanding that we have faith in anything other than the Constitution and the guarantees that it provides would mean alienation from the nation that we all know and that we all love. I believe in us. I believe that we can be better than this. I believe in my government and I believe in my justice system. I believe in the freedom and I believe in equality. I believe in the United States of America, but it's not the states that make us great. It's the people. Every individual has a duty to care for those below them. As long as everyone fulfills his function, justice, which is a manifestation of divine law, will prevail. The alternative is chaos. But that's not a world that we have to live in. We, the people, control our destiny because we, the people, give the government the power to govern to the consent of the governed. In the words of our founding father, George Washington, the basis of our political systems is the right of the people to make and to alter their constitution of government. But the Constitution, which at any time exists till changed by an explicit and authentic act of the whole people, is sacredly obligatory upon all. The very idea of the power and right of the people to establish government presupposes the duty of every individual to obey the established government. To present these facts, I will be as harsh as truth and as uncompromising as justice. Therefore, I appeal to the just God and supreme judge of the world on behalf of all the good people of this nation, whose rights and freedoms have been robbed from them by this government. The Ninth Circuit applies a two-part test to determine abuse of discretion. Number one, did the district court apply the wrong test? Fact. This is a deprivation of a fundamental constitutional right for a suspect classification under the color of state law in violation of the United States Constitution. Therefore, it is an equal rights of law and equal protection under the law matter, as clearly stated numerous times. As a result, the unconstitutional state statute must withstand strict scrutiny and the compelling state interest test must be used. The court's use of the lesser discretionary test, after being clearly informed numerous times of the correct test to be used, is an obvious abuse of discretion and therefore an improper and illegal ruling occurred. State prisoners can win federal writ of habeas corpus only upon showing that the state participated in a denial of a fundamental constitutional right. See Oliver versus Wainwright, 1984. 1B. Any erroneous view of the law is automatically an abuse of discretion. Fact. The district court's opinion that a judge-made ruling is in legal contemplation superior to the clear provisions of the United States Constitution is an obvious erroneous view of the law, and therefore an automatic abuse of discretion has occurred, making the ruling improper and illegal. Where rights secured by the Constitution are involved, there can be no rule or legislation made which would abrogate them. Miranda versus Arizona, 1966. Fact. Every public officer commits extortion and oppression who, in the exercise or under the color of exercising the duties of his office, abuses any discretionary power with which he is invested in law. Black's Law Dictionary, 2009. Number two. In accordance with Article 6 of the United States Constitution and Title 42 or Title 4 USC 101, the district court judge is bound by oath or affirmation to support the U.S. Constitution, of which violation of the law results in the crime of perjury. The judge has undeniably breached his oath and failed to fulfill his duties imposed and defined by law when he willfully chose to support the Washington State Constitution and a judge-made ruling instead of the object to which his fidelity is bound. As a result, his willful and knowledgeable violation of the oath he made upon entering into his office has now resulted in his guilt of the crime of perjury, as clearly evidenced by the facts of the case. The judge is also now guilty of the crime of extortion due to his abuse of discretion, as clearly evidenced by the facts of the case. Therefore, in accordance to Article 3 of the United States Constitution, the district court judge is no longer fit to continue in his office, as he is no longer in good behavior and has knowingly and willingly engaged in criminal behavior and undeniably committed the crimes through the intentional abuse of his powers vested in him by the laws, as well as the violation of the faithful duties and oaths of his office in which he serves. His acts were neither harmless nor a mistake, as the record will reflect that he was clearly informed numerous times of his criminal negligence and wanton misconduct, to which he consciously chose to proceed with reckless disregard to his legal duties. And despite awareness of the criminal conditions, his immunity applies only to civil liability, although malice exception may be appropriate in this case, as the doctrine of master-servant placed willful and negligent damages onto third persons by agents upon the agent's master. However, in accordance with the United States Supreme Court decision in Imbler v. Pac-Man, even judges cloaked with absolute civil immunity for centuries can still be held criminally liable for willful deprivations of constitutional rights. Therefore, the district court judge has no immunity from the crimes of obstruction of justice, perjury, and extortion. This court now has foreknowledge of crimes which have been and are being committed against the petitioner, and now has a fiduciary duty to report those crimes, of which failure to act and report the crimes to the proper authorities for adjudication will be a violation of a statutory obligation, and perhaps the crimes in misprison, Title 18 USC Section 4, and conspiracy to obstruct justice, Title 18 USC Section 371, Title 42 USC Section 1982, Section 2. If two or more persons conspire for the purpose of impeding, hindering, obstructing, or defeating in any manner the due course of justice in any state with the intent to deny any person or citizen the equal protection of the laws, and Title 42 USC Section 1986. Every person who, having knowledge of any of the wrongs conspired to be done and mentioned in the preceding section, are about to be committed and having the power to prevent or aid in the prevention of the commission of the same, neglects or refuses to do so, may be joined as defendants in the action. The district court's ruling was born out of the judge's crimes and the court's breach of legal duty. This is a miscarriage of justice and therefore illegal and invalid, as it is predicated upon a criminal act made by a person who, in accordance with the United States Constitution, no longer has the authority to rule on the merits of the petition. No one, including district court judges or any officers of the judiciary, have the right to break the law or breach the duties imposed by positive law. Number 3, in accordance with constitutional law, Section 171, State courts and federal courts are equally obligated to guard and enforce every right secured by the federal Constitution. An obligation refers to anything a person is bound to do or forbear from doing. Looked at from the perspective of the one bound, the obligation is a duty. Looked at from the perspective of the one entitled, the obligation is a right. The courts of the state of Washington undeniably breached this duty or obligation to guard and enforce every right secured by the federal Constitution the moment that it began enforcing a law that abridges the privileges and immunities of United States citizens secured by the United States Constitution. The federal district court has now breached this duty and obligation to guard and enforce every right secured by the federal Constitution in its ruling in favor of laws and rulings that are contrary to the United States Constitution. Any unconstitutional law, be it a statute, ordinance, regulation, custom, or judge-made ruling, is in legal contemplation no law at all. It secures no rights. It imposes no duties. It provides no protection. No court is bound to enforce an unconstitutional law. No person is bound to obey an unconstitutional law. Number 4, the district court judge ignored material evidence presented to him on numerous occasions, as the record will reflect, thus resulting in a highly biased and prejudicial ruling, which is contrary to law, as well as violates the statutory obligations imposed upon the judge by positive law. 3 separate times, the judge was clearly informed of the ineffective corrective process by way of statutory exemption to the exhaustion of state remedies mandate. And all 3 times, the judge outright ignored and failed to address the evidence raised. Furthermore, the judge was informed numerous times, as the record will reflect, that this petition is controlled under the prescriptions of Title 28 USC 1343 as a civil rights violation, and imposing the statutory obligation on the federal district court to rule on the petition first and before any other court, including the courts of the state of Washington. The court's refusal to rule on the petition first and demand that the petitioner seek a state court ruling before it will act is a blatant disregard of the positive laws enacted by the people and the duties that they impose by shifting original jurisdiction from its own court onto the courts of the state, contrary to law. The courts are tethered to positive law and do not have legal authority to violate or change the laws enacted by the people. If there is any legal authority that supports the court's refusal to rule on this petition or is contrary to provisions of numerous authorities presented by the petitioner or reflected by this case, it should be presented to the record and let it be known. Otherwise, it is a willful, knowledgeable, blatant, and reckless disregard of the law and the court's legal duty to act. Additionally, the court's failure to cite any legal authority, positive law made by the people, that supports the judge's opinion or that counters the numerous authorities presented by the petitioner is evidence that in arriving at the finding of fact, the judge ignored and erroneously excluded material evidence and determined the facts in an incomplete and unfair manner. Additionally, neither the court nor the state addressed either of the claims raised within ground 2 of the writ habeas corpus, nor did the court or the state address the claims raised within ground 3 or ground 4 of the writ habeas corpus. Although there's no denying or excuse for the obvious violations of the claims raised in grounds 4, in all 4 grounds of the writ habeas corpus, it makes it reasonable to assume that neither the court nor the state would want to address these issues. This act of deliberate indifference demonstrates extreme bias and prejudice, as there was no consideration of the totality of the petition. Simply choosing to ignore the evidence presented does not make it cease to exist. Designing to only consider part of the claim and ignore the rest proves bias, prejudice, and partiality. This partiality is contrary to the court's legal obligations. It violates the petitioner's legal rights. It improperly administers justice. It imposes unfair and unequal treatment of the people. It is highly destructive to American constitutional laws, and it brings dishonor upon the credibility and sustainability of the justice system, and is by its very nature criminal. This is not a harmless error or mistake, as a mistake results in corrective action and repentance once made aware of the conditions. Since a conscious decision was made to proceed, despite being made fully aware of the illegal conditions, as the record will clearly reflect, this is no longer a claim of a mistake or an error. It is now willful defiance of the United States Constitution and willful, knowledgeable, and reckless criminal acts. Judges are legally bound to fidelity with and to the United States Constitution in accordance with Article 6. Judges are independent. Their oath is direct, and they cannot blame someone else's infidelity or another branch's act or decisions as the cause for their own criminal acts or negligence. Ignorance is not defense. Simply because you do not understand the laws of gravity or believe in the laws of God does not mean that you're not bound by them. Lack of knowledge resulting in a violation does not eliminate you from the ramifications of such violations. The illegal and highly destructive acts perpetrated by the justice system, although I did not believe that they were intentional or malicious, does not negate their existence. Crimes done secret and in the dark are still crimes, and justice still deserves to be rendered. Number 5. In accordance with Canon 1 of the U.S. Judiciary Code of Conduct, a judge should be independent, but they must comply with the law. Simply carrying the title judge does not provide an entitlement to violate the law, either personally or professionally. The bench in law provides no protection from willful criminal acts. In the wise words of our Lord Jesus Christ, you are so proud of how well you know the law, yet you dishonor God by breaking it. Interestingly, that statement was directed at judges then, just as it is now. Negligence of one's legal duties or predicated upon one's decisions, upon the erroneous and illegal decisions of someone else, and not in relation to the object of which the person is legally bound to protect, does not hold the person harmless for the breach of duty. A judge must conduct himself in a manner consistent with the expectations of the office for which he serves, as well as the duties impressed upon him and assigned to him. In accordance with Canon 2A, an appearance of impropriety occurs when reasonable minds, with knowledge of the relevant circumstances disclosed by reasonable inquiry, would conclude that a judge's honesty, integrity, and partiality to serve as a judge is impaired. It is safe to conclude that given the facts of this case, the evidence available, the data compiled, no reasonable person could conclude that a judge did not act with dishonesty, without integrity, with extreme partiality, and with clear criminal intentions to compel a result by illegal means, extortion, or failed to act when there's a duty to do so in reckless disregard of the petitioner's rights, coupled with knowledge that an injury will occur, wanton misconduct, and a conscious, voluntary omission in reckless disregard of legal duty, of which the consequences to the petitioner, gross negligence. The law is clear. Every public officer commits extortion and oppression who in the exercise or under the color of exercise in the duty of his office abuses any discretionary power with which he is invested in law. Number 6, the court has stated it is unclear whether the unexhausted claims are potentially meritorious. This statement is absolutely ridiculous. However, for clarity, consider the following. Number 1, the Fifth Amendment to the United States Constitution states, no person shall be held to answer for capital or otherwise infamous crime unless on the presentment or indictment of a grand jury. Fact, petitioner was held to answer for an infamous crime without a presentment or indictment of a grand jury. The United States Supreme Court has already ruled that petitioner is entitled to release if petitioner is held in custody in violation of the Constitution or the laws of the United States or an act done or omitted in pursuance of a law of the United States. He must be discharged. See, in Re Looney and in Re Viegel. The district court's failure to act is not only a violation of the United States Constitution, but also in violation of the orders of the highest court of the land. Number 2, Article 4, Section 2 of the United States Constitution states, the citizens of each state shall be entitled to all privileges and immunities as the citizens in the several states. Fact, petitioners being deprived of a privilege and immunity secured by the federal Constitution and enjoyed by citizens in other states. Title 42 USC 1981 states, all persons within the jurisdiction of the United States shall have the same right in every state to the full and equal benefit of all laws and proceedings. Number 3, Article 6 of the U.S. Constitution states, this Constitution and the laws of the United States shall be the supreme law of the land, and the laws of any states contrary notwithstanding. Fact, the state of Washington has a law in place which functions directly to the contrary of the U.S. Constitution and is being enforced despite its unconstitutionality. An unconstitutional act is not law. It confers no rights. It imposes no duties, affords no protection. It creates no office. It is in legal contemplation as inoperative, as though it had never been passed. Norton versus Shelby County. Fact, the legislative branch makes or changes laws based upon the decisions of the people in accordance with Article 1 of the United States Constitution. This separation of powers is designed to prevent arbitrary or capricious ruling. The people of the United States choose to change the Constitution and not judge their states in accordance with Article 5. Number 4, Amendment 13 to the U.S. Constitution states, neither slavery nor involuntary servitude shall exist except as a punishment for a crime whereof the party shall have been duly convicted shall exist within the United States or any place subject to their jurisdiction. Fact, duly is defined by Black's Law Dictionary as in accordance with proper procedures. The state of Washington has enslaved thousands of United States citizens, including the petitioner, and forced them into involuntary servitude in order to generate revenue and profit for the state through the illegal enterprise of human commodity. The state has done this in a manner contrary to the established procedures set forth by the United States Constitution and therefore not in the duly or due manner. And its slave industry, disguised as justice, is in violation of the 13th Amendment. This prostitution of our government in order to advance the selfish or financial gain of the few at the expense of the many is a disgrace to us. Ought not all the safeguards of liberty known to a civilized and humane jurisprudence be introduced so that a free man may not, in any case, be surrendered as a slave? President Abraham Lincoln. The purpose of the writ habeas corpus is to safeguard a person's freedom from detention in violation of constitutional guarantees. See Blackledge versus Allison, 1977. Number 5, Amendment 14 to the U.S. Constitution states, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Fact, there is no denying that the state has enacted a law that has abridged the privileges of United States citizens, and there is no denying that the state enforced a law that abridged the immunities of the petitioner when he was held to answer for an infamous crime without a presentment or indictment by a grand jury. States cannot substitute their own alternative legislation for the federal laws and regulations. If, in the opinion of the people of the United States, the guarantees or freedoms of the United States Constitution be in any particular way wrong, let it be corrected by an amendment in the way in which the Constitution so designates, until, if and when that time comes, every single United States citizen, including the petitioner, is entitled to every single right secured by and enumerated in the United States Constitution, including an indictment by a grand jury. With all due respect to the court, if these violations of the United States Constitution are still unclear as to whether or not they're potentially meritorious, then this may not be a legal issue, rather a competency issue. The court will have a very hard time, if not impossible, finding even a single reasonable jurist and United States citizen willing to rule against the merits of the petition, as that decision would adversely impact their own constitutionally guaranteed freedoms. While it's not the responsibility of a subordinate to probe the motivations of his superiors, if he has good reason to believe that his master's cause is unjust, he should obey his conscience and refuse to comply. Ultimately, the servant of a tyrant cannot take refuge in the excuse that he was just obeying orders. Therefore, in the wise words of President Abraham Lincoln, I do suggest that it will be much safer for all, both in private and official stations, to conform to and abide by all those acts which stand unrepealed than to violate any of them, trusting to find impunity and having them held unconstitutional. So I remain patiently waiting, believing in the justice system and faithful that it still works, because if not, then God help us all. Respectfully and peacefully, a servant of justice, Tanawa M. Downing.